SJC-13617, TJR Services, LLC versus William L. Hutchinson et al.
Good morning, Your Honors. If it pleases the Court, my name is Rosemary Trainey, and together with Jeffrey Johnson, we represent the appellant, TJ Services.
Great.
We're here this morning seeking a reversal of the single justice's order denying our client use and occupancy in the housing court. In this case, it's a little bit helpful, I think, to go back a little bit to see how we ended up where we were in the housing court at the time. TJR Services had brought a case against the Hutchinsons in the land court, and after a trial and 2 summary judgment hearings, obtained a judgment in the land court that it held title to the property and that the Hutchinsons had no right to title to the property. We then took that judgment and...
Could you go back one step?
Sure.
Just the original decision in the housing court, was that a dismissal without prejudice?
Yes, it was.
Okay, so it was...
And just to clarify, that decision from the housing court was raised by the Hutchinsons in the land court case on a motion for summary judgment based on res judicata principles. It was denied in the land court, and they reserved their rights on appeal, which that piece of it is under appeal in the case that's pending in the appeals court between the parties. Mm-hmm. So we obtained the judgment in the land court. We then filed a summary process action in the housing court, fully intending that we were going to take our land court judgment and move for summary judgment in the housing court, with the only issue being whether or not notice was proper, but other than that, title had been adjudicated. Mm-hmm. The Hutchinsons filed a motion for staying the proceedings while the appeal was pending of the land court decision. We made a determination that that made sense, practically, economically, not to proceed while the land court judgment was on appeal. Our only requirement was we wanted use and occupancy while the housing court matter was stayed. The Hutchinsons objected to that. We had a hearing before the housing court judge, and the housing court judge likened it really to no difference between this being an appeal that he was staying at the request of the Hutchinsons, and if there had been a judgment in a housing court case and it was up on appeal and the proceedings were stayed pending that appeal, and an order for use and occupancy could be entered. And before we could get that far, there was an appeal taken to the single justice. We believe that the single justice's decision was incorrect because not only did we have the summary judgment decision, the judgment from the land court that we were relying on, and that would have entitled us, we believe, to use and occupancy pending while the stay was in effect, so that they could take their appeal.
Counsel, you say that the single justice was wrong, and I know that you just said that Judge Michaud had a different viewpoint than the single justice, in as much as the single justice seemed to be focused on the fact that you're in different courts, and the fact that you got your title determination in the land court, and you made a conscious decision not to go and have it adjudicated in the housing court. Is that a distinction without a difference, a legal difference?
In my mind, it is. We went to the court where you would go if there was a title dispute. We obtained a judgment from the land court. That judgment's entitled to full faith and credit in the housing court, even if it's on appeal. And we took it to the place where you go to get possession. That's what we did. So we knew that we couldn't get use and occupancy during the pendency of the land court action, and nor did we seek it. We were merely getting the title issues resolved.
So under what legal theory, because I thought looking at the single justice's decision, he was focused on there doesn't seem to be any authority for the housing court to issue a use and occupancy order without an underlying decision or judgment of their court. What's your best authority for why the housing court can do this in another department?
Well, the way that I read the cases out of this court, King and Davis, and most recently Frechette, is that the general policy of this court is that you can dispute title, but while you're doing that, there has to be some balancing of the equities between the record title owner of the property and the foreclosed owner of the property who's a tenant at sufferance once the foreclosure happens. And the way that I view it is, even if the single justice thought that the housing court judge didn't have authority to do it, albeit because he said that the decision came from the land court, not the housing court, I believe he would have had that ability to do it even if there was no judgment at all. If we had gone in on a straight summary process case, and for whatever reason there had been a request for a stay, which in this case the defendants made the request, the judge could have determined that to enter the stay and that to order use and occupancy. Under certain circumstances, at least my reading of both King and Davis is that under certain circumstances, a housing court judge can order use and occupancy during the pendency of an eviction proceeding. So I don't think that, judgment aside, I think all the judgment does is put us in a position where we were entitled to the relief we were seeking, because the only response that the defendants would have had would have been to respond to a summary judgment in the housing court. So there really wasn't any factual dispute that would have arisen in that regard. So he could have done it on that basis, which Judge Michaud did, but he also, I think, could have done it strictly on...
Was that just on a general equitable power basis, or was there some specific statutory language that Judge Michaud could have done it?
He did it on his general equitable powers, and in a situation where, and I think he even went even further than that and said that what he would have done, had he been given the opportunity, was he would have escrowed the lion's share of the use and occupancy and ordered only that the real estate taxes and the insurance be paid in order to preserve the property, and that way neither party would really be negatively affected by it, because paying the taxes and insuring the property would benefit both of them. So I think that his decision to allow a use and occupancy payment while the stay was pending, again, made sense.
As a practical matter, what happens if the land court decision gets flipped? In terms of, let's say, there's ongoing payments of use and occupancy in that, per the housing court's order, and then the appeals court decides the land court was wrong.
I think that that's what Judge Michaud was doing when he said that what he intended to do was only order that the real estate taxes and the insurance be paid, and that the rest of the money be held in escrow.
I understand that that's the sort of a way to ensure then the money goes back.
That's correct.
To the
That's what his
rightful
position
owner.
was, is it would go back to, if TJR was successful, the money would go to them. If the Hutchinsons were successful, the money would go back. And either way, the taxes and the insurance were being paid. So that benefited either party.
So I have a related question. If we were, what's been going on since the single justice's order that's on appeal now? Have the use and occupancy payments continued to be made?
There are none. We never got to that. We never got that far. What happened was, before Judge Michaud
Oh,
could
so they
even
never
enter an
started
order,
at all? Okay.
right, before he even entered a money order, the appeal went up.
So there's
And,
nothing in escrow? What's been going on with the taxes?
Our client's been paying the taxes
TJR
as
is
the owner,
paying
as the record title holder of the property. And the appeals court case is still pending. So, and again, we have a situation here where we have,
Can I ask one sort of follow-up? On the original, because he's going to get up and argue that res judicata should have applied to the housing court decision. Did the judge explain why it was a dismissal without prejudice, even though he's the first time around? In the housing court, he dismisses it without prejudice, right?
a different judge, yes. The housing court judge at the time dismissed the case without
Does he or she
prejudice.
explain why it's without prejudice, even though they find that it's a different title holder?
Well, the judge in the housing court didn't. The dismissal was simply, I'm dismissing without prejudice the claims and the counterclaims, and that was kind of it.
Okay.
the land court judge, in his determination that he took the position that it wasn't res judicata, was because he took the position that the housing court judge had raised the issue sua sponte, and that neither party had argued the issue of the title issue. The judge brought it up on her own and then dismissed the case. And again, I think the issue,
And then the land court judge finds that the housing court judge has done that incorrectly, I take it, right?
no, the land court judge found, well, yes, the land court judge found that the issue of the name of the party was de minimis in his decision in the land court case, but he found that the dismissal was.
That down just for us? There's a one-word difference between, it's a trust, there's the word trustee is in there? I can't remember what the difference is.
The way that what happens is, and I can't,
Because I spent,
you'd think I would know the name by
he's got 20
now.
pages on that, and if you could simplify that, it would help.
Right. So what it is it's one of the, like a pass-through trust. And it's in some of the documents that were on record, it says the ABC Pass-Through Securities Trust. And on some of the documents, it says the ABC Pass-Through and doesn't have the word trust. The word trust was left off of some of the documents that were recorded in connection with the foreclosure process. And the land court judge determined that the omission of the word trust was de minimis in the general scheme of the foreclosure. But again, I think that our position would be that this argument that my brother's making with respect to the res judicata of the first housing court action in this case is not relevant, because he's raised that in the appeal in the land court, because that's where he raised the issue. He shouldn't be entitled to collaterally attack the judgment of the land court now in the housing court. That's what his appeal is for, and that's why we're arguing that on appeal when that appeal is heard before the appeals court. And he'll have the opportunity to argue that then. So I don't think that that's relevant to the discussion of whether or not we should have been entitled to seek use and occupancy after the land court judgment.
So one of the things that we haven't talked about is the issue, preclusion issue, about that your client has right, title, and interest to the property that was made in the land court. Your brother's going to argue that O'Brien doesn't control this, and is the issue that is O'Brien not controlling because it was an arbitration?
It's not my reading of O'Brien. My reading of O'Brien is that this court held that a decision of a trial court is binding, even if it's on appeal. Didn't say only in arbitration cases. It said it was adopting the federal rule and the majority rule in most of the states that cases that are on appeal are still considered final judgments, even if they're on appeal. I understand that that's the argument that my brother makes. That's the argument that the amicus brief made that was filed last night. But it's our position that both O'Brien and Campos versus Van Houten that came after O'Brien, that they both came to the same determination that it's res judicata. It's not subject to collateral attack, even if it's on appeal. Lastly, I would say that this particular set of circumstances as well, and following along with the decisions in in King and Davis, is here we have a situation where we have defendants who have vociferously taken the position that they are the owners of this property. They have, by their own admission in the land court, did not make a mortgage payment from 2010 until the foreclosure in 2016. And the bank foreclosed in 2016. The property was sold in 2017 and then again in 2019. They have not made any payments to real estate taxes during any of that period of time. And at least as far as when the housing court action that we filed was made, they acknowledged that they did not have insurance on the property. And so I think that from a balancing of the equities perspective, they should have every right to challenge whatever they want to challenge with respect to whether this foreclosure was proper. But it's our position that they should pay while that process is going on because our rights are being affected by their exercising their rights.
Okay, thank you.
Thank you.
Attorney Vauter?
Good afternoon, Your Honor. My name's Tom Vauter, and I represent the defendants in this matter. I guess I think it's important to address the question that Justice George raised as to whether it's a final judgment or not in the land court, and I would suggest that it's not. And where I'd come from is I would look at the reporter's notes to Rule 54, which says, Rule 54A crystallizes the meaning of a judgment and final judgment and emphasizes the difference between these terms and the concepts of judgment under pre-existing Massachusetts practice. Heretofore, judgment was meant the last step in the case, which cuts off all appellate review. Under the rules, judgment is merely the final adjudicating act of the trial court and starts the timetable for appellate review. Briefly stated, a case which went to judgment under the old practice was, except in rare circumstances, forensically dead. Henceforth, a case in which judgment is entered is ready for appeal.
But could that trump what we said in O'Brien? And I guess I go back to, I know you dispute this, but O'Brien says what it says. And since O'Brien, there have been other cases where that same principle has been reaffirmed. And so I just don't understand why it is that the summary judgment adjudication in the land court isn't final for purposes of title.
So I would argue that before this court, the court has ruled in Spiney versus Previtt or acknowledged this very language in Spiney versus Previtt. And I would suggest that there's another case, appeals court case, Gonzalez versus Spates, that Judge Kafka issued back in 2002, 554 Mass Appeals Court 438. It was a different set of facts, but he again cites this reporter's note as applicable.
On the issue of issue preclusion?
On the issue of whether the judgment is final or not, whether a
But
judgment,
not in the context of issue preclusion.
and so I think why the facts on O'Brien. I think the facts are important in O'Brien, and the reason the facts are important in O'Brien is that is an arbitration case. And an arbitration case is where two parties contract to not come to the court, but to go to a different process.
And if I could just follow up on that distinction you're making on O'Brien. O'Brien cites a series of federal cases and the majority view on the finality required for issue preclusion. Are all of those, I haven't done that work, I'm assuming you did, are all of those federal cases and the restatement of judgment second that it cites also, are all of those arbitration cases?
It is my
It's okay
belief-
if you don't know, I will look it up.
So
but-
I haven't read all of them, but it's clearly, arbitration is a very particular set of circumstances in which there's very limited opportunity for review in this court system, in the Superior Court system. So there's only 3 or 4 reasons that you can say, I'm not doing, once you agree to arbitration, not to do arbitration, or if there was fraud, there's very limited reasons. And so the arbitration is, if you agree to that, and you agree to that process, you may have a few opportunities to come to Superior Court. And if you come to Superior Court, and one of the notions under the arbitration rules is that it's a way to get a quick resolution of disputes.
So your position would be that there is one rule for issue preclusion as it regards arbitration cases and a different rule for everybody else?
I think that there is a general rule that's consistent with the reporter's report on 54A. I believe that that's the general rule. I believe that this court did take up the O'Brien case and did rule on the O'Brien case, but it is an exception. It is a carve-out about arbitration cases. And
Okay,
to
so
apply
yes,
it-
you think arbitration cases are different for purposes of issue preclusion?
Absolutely. To make a general statement of that on all other cases seems not appropriate. And I think given the confusion that I agree with Justice George, there are other decisions subsequent to O'Brien that sort of seems to public policy, not against public policy, and it seems to me that this court would be helpful in this particular case.
O'Brien cite two federal cases that are not O'Brien relies on two federal cases that are not arbitration cases. They're not, it applies it in the arbitration context, but the federal law is not arbitration law, right? I mean, I may be misremembering those cases, but I thought the U.S. Supreme Court case and the First Circuit case are not arbitration decisions.
I will not dispute you because I do not know for a fact, okay? So what I will say is that it's clear that this should not be the rule for the general cases that go to trial or go to judgment.
Why not?
Because the right to have an appeal, is what has been basically guaranteed or basically recommended by the courts over the years. Now, I understand that this reporter's note says that there's a prior rule and now we have a new rule, but it's been a long time. The rule has been if you have a judgment, you have a right to appeal that.
He is
And
appealing.
that,
They are
until a
appealing.
rescript opinion is issued by the appeals court, it does not end the case.
What happens to the obligation to pay on a judgment when it's entered in the trial court?
I believe it gets stayed under, I believe, certainly in summary process cases, it gets stayed if there's an appeal.
But not in
So-
summary
so-
process
so-
cases.
Excuse me?
Not in under the rules of civil procedure, not in summary process cases.
And so, but certainly under summary process, and it's a broad, so I'm not going to say, it's going to suggest to the court that there is one glove that fits all. I'm not going to say that. What I'm going to say is that arbitration cases are a separate animal, different from the general run-of-the-mill based on the nature of arbitration and based on the nature of where it comes from and the rights of a party to come into the court.
If that's the carve-out, doesn't it put the trial courts in a strange position where the housing court judge would have to say that the land court judge was wrong as a matter of law? So basically, make the housing court judge have to rule on the validity of a ruling from another judge.
I'm not sure that that's true. I'm not sure that the housing court should get to that issue, other than the fact that it's not a final appeal. It's not a final appeal. It's up on appeal, and that
So you could have
really-
inconsistent. You could
so
have
there was a
inconsistent.
motion to dismiss along with a
But you
motion.
could have inconsistent rulings by two different judges. You'd have inconsistent rulings by two different judges if
Right.
it played out.
We're going to have inconsistent rulings. We have the 2017 ruling in which there were factual determinations made by a housing court judge that the entity that brought the case was not the correct entity. So we do have findings of fact on that. So that's going to be one piece. And there's going to now the land court that's going, I'm not bound by that. So he's going to say.
It was a dismissal without prejudice. It was a dismissal without prejudice. And are there
So-
fact findings? Do we have fact findings on this?
Fact
findings?
There is facts that the judge entered in her order prior to the entry of the judgment. I will agree that the judgment says without prejudice, but that does not mean that it doesn't become final when the parties fail to appeal. Nobody appealed the
Well, it's
housing court
final,
decision.
but it's not binding because it's without prejudice.
I don't think that's true. I
Why?
think because the entity that brought the first summary process case can't come back in. If somebody else can
Why?
because they're not the right named entity.
Oh.
That was determined that they're not the right named entity.
But that's not before us, right? I mean, that's in front of the appeals court in that vertical.
Correct. And so it's only before you to the degree that there is a prior judgment in the housing court for which they, rather than going back into the housing court, as one you suggested, why not go back in? They went to land court. They
But
didn't go back in. They didn't go,
What does that matter? They had a right to go to the land court.
they absolutely had a right to go.
Okay, so
But-
what does it matter that they chose to exercise that right?
Because there's a judgment out of the housing court
The
that
judge-
says,
I'm-
there's a judgment out of the housing court that's based on facts that are set out, that say that the plaintiff, the party that brought the case, is not the proper party. The housing court did not have, there was no standing, and there's lack of jurisdiction. So
Well,
so for them to come in and with a new party.
The first judgment was a dismissal out of the housing court, was a dismissal without prejudice, correct?
Well, it's a.
That's what it was. It was a dismissal without prejudice.
Correct. Based on findings of fact.
Based on, it looks like a technicality.
Well, so that may be, I mean,
That may be why it's without prejudice.
Well, I'm not sure that that's true.
Mm-hmm.
Because so the very same
So
set
all
of
of these
facts.
issues you can, and presumably will raise at the appellate level of the land court, right? The question before us is whether, while you're doing that, the housing court is authorized to order your client to pay use and occupancy.
And I would say not. And the reason they're not is that there is no case law. Well, so there is no case law that holds that a adverse tenant, such as a foreclosed homeowner.
Really? Don't King, Frechette, and Davis all narrow this to focus on the fact that somebody's living without paying use and occupancy, and someone else is not having any access to the house? Somebody's got to pay for the insurance and pay for the taxes, so we do a balancing there. It just seems like there's very little left that hasn't been done in those three cases, but you tell me why.
So King and Frechette were after judgment on appeal. They were not during the pendency of the case. The only case is the Davis case, and the Davis case was a holdover tenancy, not an adverse tenancy. It was somebody who had a relationship, a release kind of relationship with the landlord, who then did not leave. But in this case, where title in
Yes, Mr. King, from what I remember about Mr. King, and I haven't reread it recently, but Mr. King gets foreclosed upon. Isn't he still challenging the foreclosure when we conclude that use and occupancy is okay there? I can't remember.
So as I understand the facts of King, is that the issue of use and occupancy was raised after judgment. I would say that I think it's the Save More case, versus, all the cases talk about in an adverse tenancy, in a post-foreclosure homeowner case where title is being disputed, use and occupancy is not an appropriate remedy during the pendency of the case.
We've never said that. Cite something that says that.
Of course it's been said. It's been said for 174 years, from Miriam versus, I have it right here.
Use and occupancy statute.
Howard
is not
versus
a-
Miriam, from 59 Mass, 563.
59 Mass. When did the use and occupancy statute go into effect?
Use and occupancy statute. There's a summary process statute.
That
and the
talks
summary
about
proce-
use and
the-
occupancy.
In the summary process, the use and occupancy is, well, so,
59
I'm not
Mass
sure
is
which year-
18-something. You know.
what's that? I'm not sure.
59 Mass must be
Yeah.
the
it's
1800s.
1850.
It's-
And
it's-
the Merrill versus Bullock case, they're both good law to the very present. They're still good law.
How do you distinguish Davis?
Davis is a holdover tenancy.
It's a tenant at sufferance.
Well, and
That's
so-
what the court
so-
says. The court
so-
says, we conclude that following motion by a landlord, a court has statutory and equitable authority under, and cites to order a tenant at sufferance to make interim use and occupancy payments during the pendency of an eviction action. How is it that that does not control this situation?
Because I would argue that tenants at sufferance is now begun to be misused. Tenants at sufferance only applies to holdover tenancies, do not apply.
What's your authority for that, legal authority?
I go to these old cases again. I go to the old cases, talk about it, the Merrill versus
A
Bullock, a
tenant at
1870
sufferance
case.
is not, a tenant at sufferance is not a former homeowner, a post-foreclosure homeowner?
Correct. And I understand there are recent decisions. I'm not going to suggest that there aren't recent decisions that use that term. I think it's probably in King, it's probably in Frechette, it's probably in some recent cases. But if you were to look at the law that's still good today, it is a different relationship where title is being disputed. The question that happens in summary process is whether the plaintiff is rightfully there and whether there is rightful possession. That's the issue.
Okay, so I
not-
take it you
not use and
distinguish,
occupancy.
you distinguish Davis by saying that these, I guess it's plaintiffs in this case, are not tenants at sufferance.
My clients, the Hutchinsons, are currently not tenants at sufferance, correct? And I understand, it's been, those terms are out there, but I don't think that they're accurately being used. So,
Okay. Any other questions? So much.
thank you.